You're very welcome at this meeting of the Planning Applications Committee. My name is Councillor James Husband. I'm the chairman of the committee, and I'm joined along this table by my fellow councillors. It will be the five of us who will be making decisions on the matters in front of us this evening. We're also joined by officers who will be presenting reports and giving us advice. They are mostly seated along in front of me. The most senior officer this evening is Lisa Chung, the lady who's on Councillor Lane's immediate right, and Lisa Chung is the head of development management. Okay, so I think we can make a start. First of all, have we any apologies for absence?
No apologies.
No, we have none. Are there any declarations of interest, anyone?
No.
There are none. Are there any other declarations? Now we have the minutes of some previous meetings. And colleagues, can I ask you, first of all, if we can approve the minutes of the meeting that was held on the 10th of October, which Arian and Will, you were present. Can I sign those?
Yes. Yes.
Thank you. We then have the meeting that was held on the 5th of December. And again, Arian and Will were present with me at that meeting. May I sign that as a record? Thank you. Lastly, the meeting that was held on the 9th of January, and I think on this occasion, Will, you were present as well as myself. Can I sign that?
Yes.
That's agreed. Thank you. Sorry about that. Okay. So it might help us, I think, everyone, if I just quickly indicate the order in which we're going to consider the cases in front of us. First of all, in just a moment or two, we will consider matters at 106 Cheyne Walk. We will then move on to Durham Place, with two applications at Carmel Court, which we will take in turn. Then a site on Kensington High Street, Selwood Place, Lennon Crescent, property on the King's Road, Westbourne Grove, Kensington Mansions, and finally a property adjacent to the highway from Montpellier Street. So that's going to be our order of business. Okay, I think on that basis, I think we can get underway quite quickly. So the very first item relates to the boats moored off Chelsea, and I think Caroline Goddard. Caroline, you're going to introduce the report. So please, over to you.
Right, so as a recap, the 19th of December.
Speak up, please. Can't hear.
Yes, actually, I'm sorry.
Okay.
Yeah, I think actually, so it's not directed to you. I think for everybody, sorry, this room has ominously a slightly padded aspect to it. So I think we all of us, particularly if you're facing me into a padded wall, can everyone speak up, please? I'll try and do my best myself. So Caroline, over to you. Yeah.
Is that better?
Yeah,
Okay.
that's
On the 19th of December last year, planning committee decided that a breach of planning control had occurred at this site. That was on the basis that the introduction of 3 significantly different boats constituted a material change of use by intensification And that was due to the size of the 3 houseboats and their configuration as 2 self-contained flats. The committee requested that officers consider whether the breach of planning control was harmful and whether it was expedient to take enforcement action. And that is the subject of this report tonight. So this is the site. It's known as Chelsea Reach or sometimes Battersea Reach. It's located on the northern side, northern bank of the River Thames, adjacent to the embankment. It's bounded by a Battersea Bridge to the north and 106 Cheney Walk to the southwest. It's historically been used for the mooring of houseboats for over 70 years. The houseboats are moored in 2 groupings separated by a central gap. It's noted that the houseboats vary in size, design and condition. That's a plan of the moorings. So the site is located within the Thames Conservation Area. It's designated as site of nature conservation importance within the River Thames and tidal tributaries. It's within the Thames Special Policy Area and the Chelsea Riverside Archaeological Priority Area. This plan shows the 3 houseboats at birds indicated in red. And here's a plan of the moorings. So the 3 houseboats are the Iris in berth 5. And to note, the Iris is not at the moorings at the minute, it's in dry dock. The Pacifica in berth 11, and the Zephyr, which is this one in blue on the left, in berth 12. So that one on the right is green, that's the Pacifica. They're moored at the southwestern end of the site, furthest away from Battersea Bridge. They're the largest houseboats moored at Chelsea Reach. The Iris and the Zephyr comprise 2-bed homes. The Pacifica comprise 1 bed and 1 3-bed home. So the legal and policy framework that you're making this decision in tonight is discretionary. Enforcement action may only be taken if there is a breach of planning control that's considered to be harmful. Enforcement action should only be taken proportionally to the degree of harm. But you have the report before you, which considers the matters in detail. The main issues taken into account when considering whether it's in the public interest to take enforcement action and the effect of the material change of use by intensification on the Thames Conservation Area, considering its status. Sorry, the Thames Conservation Area, the river as a navigable route and its biodiversity, road traffic and on-street parking stress, the living conditions of nearby residents, control of waste and housing provision. I'll just run through these slides to show you. This is the view of the boats from the embankment, from the other side of the road. This is another boat on the pier which shows a comparable size. Again, other boats just showing their sort of varied design. These are boats in the eastern moorings. This is the view from Battersea Bridge. And this is the view from the opposite side of the river. So that concludes my presentation. I just want to say that it's the committee tonight to decide whether it's expedient to take enforcement action. I know it's not an unusual matter before you.
Yes. Okay, well, thank you very much indeed. I think the way in which we will do this is that we will hear first from the parties who wish us to take enforcement action. And I think if I've got my list to hand, I think we have Councillor Kamali, Councillor Burns, and then a number of local residents. Perhaps if you would all like to join us up at the table, and we might need the odd extra chair. fit you all in, if you'd like to come up to. I understand that only maybe only a few of you will actually speak, but if you all come up, because having registered, it may be that there are questions that you can chip in and help answer. So if we can, perhaps, is there anyone at that last chair at the end?
Chair, we can stand down once we've said our piece.
Okay. Okay, so I understand, Mr. Burns, Councillor Kamali, I think you would both like to speak briefly first. And it's been agreed that the councillors would actually each have 2 minutes, and then the other speakers 6. So, I mean, certainly in total, got up to 8 minutes. So who would like to start?
I'll go first, but
Okay.
should I need the full 2 minutes?
Yeah.
Thank you. Mr. Chairman, committee members, I shall keep my comments brief as we've already debated the planning arguments. We are here tonight to decide whether or not it is prudent for enforcement action to take place. Members have already come to the reasoned view that these larger subdivided houseboats constitute an intensification of the planning use. We are not here to reopen that debate, but it's to decide whether the council should use the powers that it holds. When deciding to take action, we must consider whether it is expedient, and it is absolutely right for officers to exercise sensible discretion. But in this case, I believe it is fundamentally expedient to take this action. The complexity of the site needs to be resolved once and for all. I therefore ask the committee to authorise the action before us, and hoping you shall, is then for officers to fulfil their duty to the organisation and to the residents and act upon the will of the democratically elected members. Thank you.
Yeah.
Thanks. Houseboats in Chelsea Riverside have been a topic of contention in recent times, with concerns raised by the intensification of these floating residences due to their size, configuration, and 2 self-contained units. The issue of planning control breaches has come to the forefront, prompting calls for enforcement action by officers. Currently, there are 55 houseboats moored in Chelsea Riverside area, with 2, soon to be 3, in particular, standing out as the largest, most controversial. These houseboats are located within the Thames Conservation Area, which is a designated site of natural conservation importance and falls within Thames Special Policy Area and Chelsea Riverside Archaeological Priority Area. In addition, the addition of 3 new larger houseboats in this area is causing concern among residents and local councillors. The strain that these new boats will put on the local area is not in keeping with the established layout and community of Chelsea Riverside. The intensification of houseboats in this area threatens to disrupt the natural habitat and beauty of the Thames Conservation Area, which is a valuable resource for both residents and visitors. The breach of planning control by these houseboats should be reason enough for enforcement action to be taken by officers. The size and configuration of these floating residences make them stand out from the rest and have raised red flags regarding their impact on the local environment. It is important to protect the integrity of the Chelsea Riverside area and ensure that any development or changes to the landscape are in keeping with the established community and natural surroundings. In conclusion, the intensification of the houseboats in Chelsea Riverside is a cause for concern, particularly in relation to the size and configuration of these floating residences. The last committee was unanimous in feeling the need for enforcement, and I hope this committee will feel the same way. Thank you.
So, members of the committee, my name is Andrew Prynne, and I've been asked to speak on behalf of all the 4 residents' associations. And I aim to be about 4 to 5 minutes, probably. The associations are the Chelsea Society, the Cheyne Walk Trust, the Lots Road Neighbourhood Forum, and the Chelsea Reach Boat Owners Association. And the other members are here to answer any questions that the committee may have. I hope the committee will have had some chance to read our written response to the officer report and have found that helpful. It was sent on the 23rd of February. The starting point is the last committee's unanimous decision to overturn the officer's recommendation and find that there is a breach of planning control. And I note that Councillor Lane was a member of that committee. First, you should not be deflected in any way from your task by what appears to be the tactical device adopted by CYBC to issue a CLUDE application, a Certificate for Legal Established Use application, last Thursday. The application, so far as I can see, appears to be fundamentally misconceived because it seeks to go behind a decision that's already been made, namely that there is a breach of planning control. If CYBC don't like that decision, or indeed any decision you make this evening, of course, the right route is a right of appeal, as we all know. You must simply decide, under section 172 of the Act, whether it is expedient to order enforcement having regard to the local development plan and any other material considerations. And that phrase, other material considerations, of course, encompasses harm, but it also encompasses wider issues too. But I shall address three issues, which is first, the immediate harm, secondly, the future harm, and thirdly, other material considerations that we submit you should take into account when exercising your judgment on this matter. There is immediate harm to the riverside environment, in the view of everyone, so far as I can tell, except the officers. These new box-shaped apartment boats are much longer, wider and taller than any existing single dwelling houseboats on the moorings and massively larger than most. First, the committee by its decision on the 19th of December accepted that on a boat by boat basis and viewing the moorings as a whole, each new boat amounted to intensification by reason of its size and multi-occupancy. And Councillor Lane will no doubt be able to confirm that rationale. Secondly, the new boats block the view of the river for all those passing both sides of Cheyne Walk, particularly at high tide. I note the photograph was shown to you, which appears to have been taken at low tide. The new boats block the view of the river for all those passing on both sides, as I say, and that is a major factor for walkers, bicyclists, runners, and of course, those who live there. Thirdly, the new boats are wholly out of character with the traditional and historic view of the houseboat community at Cheyne Walk that is well known far and wide. This historic character is hugely valued by those who live in and who visit this part of Chelsea, as the 140 or so letters sent to this council for the last meeting testify. I come secondly to the question of future harm. Finding that there is a substantial breach of planning control, but then not enforcing it, condones and encourages unlawful and unrestricted development on the river at this precious site in a conservation area. Secondly, there are several more such apartment boats inbuilt at a yard owned and operated by the same owners as CYBC, awaiting this decision. If it is not enforced, they will arrive on the moorings and cause more harm. Thirdly, you should have regard to the unanimous vote of the full council meeting on the 31st of January of this year in support of a motion to preserve and conserve the riverside and protect it from unrestricted development. Lastly, other material considerations. The human cost of the introduction of these new apartment boats is the removal of the existing boats and the eviction of their owners and or occupiers to make way for them. The officers say that this is an irrelevant consideration. We submit that it is highly relevant and that the Act certainly permits it as a material consideration. First, as a matter of policy, the Royal Borough of Kensington and Chelsea considers the protection of local communities a primary consideration. Secondly, Article 1 of the first protocol of the European Convention, helpfully referred to by the officers at paragraph 11 of their report, protects the boat owner's property rights every much as it does the rights of CYBC. Thirdly, under section 149 of the Equality Act, also helpfully referred to by the officers in their report at paragraph 9, means that you must consider the impact of not enforcing, as well as the impact of enforcing, of not enforcing upon those who have what's called protected status under the Act. Contrary to what the officers were told by CYBC, there are in fact a number of boat owner occupiers who, by virtue of age and disability, have protected status, and some of them are here. Lastly, conclusion. We call upon this committee to order enforcement of this breach of planning control without delay. There is overwhelming evidence of immediate harm and the likelihood of future harm and damage to the community that will result from non-enforcement. A decision not to enforce will lead to a planning free-for-all on the river at Chelsea, with developers secure in the knowledge they need not engage in the planning process, because even if they do break the law, the council will do nothing about it. Thank you, Mr. Chairman.
Thank you very much, Steve. Perhaps I could ask council colleagues, would you mind just perhaps standing at the back? So we need 2 seats. Can I ask Mr. Taylor and Mr. Collins if you could come up and join us maybe at the table? Who's going to Yeah. Good evening. Thank you for coming along. I think Mr. Collins, you were going to start. Is that right?
Yeah, that is correct. So only I will be speaking. Mr. Taylor's here to answer any questions. Can you hear me before I?
Yeah.
Yes. Very good. Well, you actually you got almost 10 minutes in fact if you need it, but please, when you're ready.
I don't think I'll need it. Chair, that would be a record for me on speaking to a planning committee. So. Good evening, everyone. My name is Charles Collins. I'm a planning director at Savills. I'm a chartered town planner. I'm speaking on behalf of the Chelsea Yacht and Boat Company. I would like to thank you for giving me the opportunity to speak in relation to the alleged enforcement breach at 106 Cheney Walk, Chelsea Reach. So some opening remarks from our clients. It is worth explaining that our client has reached out to societies and members and wishes to continue the dialogue. I wanted to say that at the start. I appreciate that the views tonight will be against what I'm going to say, but I'm entitled to say it, so please respect that. It's regretful that this case has been brought in front of you at the committee. It's already been established by your own officers and indeed the leader of the council that no breach of planning has occurred. I do accept the previous decision of the committee, of course. It's frustrating that the salient facts that a breach has not occurred has been overridden by what we consider to be subjective objections to the appearance of the 3 houseboats. As a reminder, and this is fairly fundamental, boats are not buildings and they are rightly treated differently by planning legislation. And on that point, I'm just going to pause just to remind the committee that the officers have recommended that no enforcement action be taken this evening. Listen to the helpful comments from your officer. And that is because not only, in my opinion, the degree of harm is minimal, but also in terms of what planning legislation entitles you to do, in our view. As members are already aware, officers have investigated 3 alleged breaches against relevant historic planning records, confirming that no breach of relevant planning permissions have occurred, and this all relates back to a planning permission in November 1978, and this is quite important. For the sake of clarity, this consent allows for the mooring of up to 60 boats on the site, positioned across 2 pontoons. The investigation confirmed that the number of boats has at no point in time exceeded 60 in total, and therefore no breach has occurred. This is the single planning unit in question. That is important, committee. And that was shown by the red line plan that was shared at the start of the meeting. It's the planning unit. Officers have also stressed that there are no conditions attached to this permission that relates to the design and appearance of the houseboats. That is also important. This is not surprising as boats themselves are movable vessels and not buildings. So to put that into context, committee, within 10 minutes, these boats could be moved and replaced by another. The committee on the 19th of December last year agreed that the houseboats are not operational developments requiring planning permission. But simply, there is no breach of planning control as planning permission is not required. My client does, of course, respect everyone's individual opinion, but the case before you, given by some residents, is in our opinion subjective and is focused on boat appearance rather than any reasoned planning judgment. And you'll be aware of the committee report this evening, of course you will. Paragraph 5.5 summarises the public comments. I would say as a planning professional that most are either not material planning considerations or where they are should be given limited or no weight. I won't go through in detail because there isn't enough time, but that's our position on those. Moving on, while strictly not required, a previous speaker has made you aware, there's Tuesday last week, Savills submitted a certificate of lawfulness application to again formalise the use of the planning unit, hence inclusive of the 3 houseboats in question. We request that you were made aware of that ahead of the committee meeting this evening. Obviously, that is for separate determination, but we've taken a step forward to do that. Nevertheless, the content of our application seeks to reiterate officers' professional judgment that no breach of planning control has taken place. This process highlights that nobody has yet indicated what aspect of planning legislation or material consideration has been breached on site. Serving enforcement notice on these 3 houseboats on grounds that are still unclear, even after officers have conducted a thorough investigation since at least June last year, would constitute a gross waste of time and resources. It would be an odd state of affairs where enforcement officers could be obliged to serve notice on the 3 boats against their own recommendations. At a time when local authority budgets are already strained, we urge members to follow expert judgment on this matter. Thank you. Ahead of the committee tonight, we have sought legal advice on our next steps. Should the committee overturn the officer's recommendation, then our client will be forced to defend its position at appeal. That would be inevitable. The committee will be aware that all parties have to act responsibly and act reasonably in order to avoid unnecessary costs. I've already introduced, and I'll reiterate, our client wishes to reach out to ensure that that is avoided. Right, to conclude, I'd like to conclude my speech by reminding the committee of the circumstances surrounding this investigation. The November 1978 Planning Commission pertinent to the case relates only to the capacity and organisation of the boats at pier. There is no relevant planning permission that relates to the physical design of the boats, as the boats are not developed. And that's a key point. We therefore respectfully request that members follow the officer's recommendation and vote against pursuing enforcement action. Thank you for your time.
Yeah, thank you very much indeed. So if everyone remains in their seats, so this is the opportunity for members of the committee to ask questions of the either party. Who would like to go first? Councillor Lane.
Thank you, Mr. Chairman. I have a couple of questions. My first question for the agent/applicant. I note in officers talk about the lengths of the boats when referring to their size. I couldn't see information in the pack on the volume of the boat, sort of either in meters cubed or feet cubed inside. Do you have that in information? Is that something you can let the planning committee know? Want to know how that compares to other boats?
I see. So I don't in terms of volume. All I know is that there are a configuration of apartments, two bedrooms. In respect of a separate process, which isn't relevant for you to consider, but it's relevant for context, there's a licence for the Port of London Authority. The vessels at the relevant tide are circa 10 metres within the limit of what they're entitled to be under the licence from the Port of London Authority. They're also, in our judgment, having reviewed the file, within the bounds of the 1978 Planning Commission. But I can't give you a volume area because I don't know it. I don't want to mislead the committee.
Thank you. And then if I may, Mr. Chairman, just a couple of questions for the objectors as well. And these sort of principally relate to section 172 of the test that we've been asked to apply. I note in the packet says that the council or this committee, in terms of applying the test under section 172, should do so in accordance with Wednesbury principles and principles of Wednesbury unreasonableness. Am I correct in saying that the test under Wednesbury, it's a very low bar for the decision maker, but a rather high bar for someone challenging that decision? Perhaps you could speak a little bit more about that test.
You are correct. For someone to rely upon Wednesbury unreasonableness in challenging a decision, they have to show not merely that the decision was unreasonable, they actually have to go one further and show that it's so unreasonable that no reasonable decision maker could reach it. To that extent, I put it this way, that it flies so flagrantly in the face of logic and the weight of the evidence as to be what we lawyers call Wednesbury unreasonable. Does that help?
That does help. And a related question, perhaps, regarding the national planning policy framework. So my first question is, I sort of note the language in paragraph 59 specifically, where it speaks about local planning authorities should act proportionately, or they should consider publishing a local enforcement plan. The word must isn't used.
No.
Does that imply that there are some cases where, even if we are not proportionate, that may be okay?
Under the Act, you have a wide discretion, because the Act itself simply states that once you're satisfied with the breach of planning control, and the plainly is, but that's been found and decided, despite what my friend says, on the 19th of December. Once that's found, the only other limb that you then have to consider is it expedient, using that word in its normal sense, to issue a notice having regard to the provisions of the development plan. So you have to have regard to it, yeah, but not necessarily be absolutely bound by it. A guideline, not a tramline. But equally, of course, you have to have regard to what are referred to in the Act as other material considerations, and you've heard me speak about that. So the Act gives you a broad discretion, and as to proportionality, what we would say is, of course, if an order to enforce was made against these three boats, it would require their removal to be moored somewhere else. That, we say, would be proportional.
Thank you. And one final question, if I may, Mr. Chairman. Staying on the same paragraph, I note that it says effective enforcement is important to maintain public confidence. And do you think if we were not to enforce tonight, public confidence would be damaged?
I do, committee, very much so. Once a careful investigation has been carried out by the last committee to find that there's been a breach on the basis of intensification and indeed multi-occupancy, both on a boat-by-boat and site basis, not to enforce sends a clear signal to developers that they can go ahead and develop on the river at Chelsea. And even if they do act in breach of planning control along the lines found by the last committee, it won't be enforced and therefore doesn't matter. And that is contrary to the public interest and would alarm anyone living or visiting the river at this point because of the likely impact it's going to have.
Thank you, Chairman. I have no further questions.
Yeah, thank you very much. Colleagues, anyone else like to speak? Actually, I'd like to ask the gentleman from Savills. We have got. I think it's entirely understandable. You don't have. You aren't able to tell the volume in cubic meters of these boats, but if we could just go back to there are pictures of the boats. No, if we go there, so the boat on the left, that is one of the boats that we're talking about. Yes,
That's correct.
right. Okay, sorry. Just so we can get a. Okay,
We can get a sense.
we get a sense of its bulk, I suppose. But okay, very good. That's helpful. Any other questions? Tim?
For the objectives,
Yeah.
could I ask if you know what the volume of the boats was that were moored there previously?
I can give you square footage,
That's fine.
if that's helpful. I don't know the volume. So far as the square footage is concerned, if you look in fact at the paragraph 11 of our written response, you'll see in fact, I think a comparison between an existing boat and the large boats. The large boats have a beam or width of 7.5 meters, which is about 24.5 feet. And they are about 33 feet overall. At paragraph, meters, sorry, yes. At paragraph 12, what I've calculated is, I think, just give me a moment. Yes, paragraph 14, actually. Houseboat Stow, for example, is an 86 foot boat, it's about 26 meters. And it has a width which gives rise to I think a square footage of 213 square meters. That's 2,300 square feet. One of these new boats over 2 decks, and we're measuring it over 2 decks, since that's I think how residential properties are generally measured, comes out at 495 square meters. That's 5,328 square feet divided into 2 apartments. So more or less, these new boats, at least in terms of area, are broadly double the area of the existing boats referred to by the officers as comparators.
And can you ask, are there any of the other 50+ boats that have more than one dwelling?
There is only one, which again was brought in by this company, which is at the end. It's called Viceroy, and that's also a multi-occupied boat. All the rest of the traditional and existing boats are single occupancy.
Thank you very much.
Yes, of course.
Thanks, Chairman. Spread, I mean, just want to understand what would, I know you raised concerns about many things about multi-occupancy, this one is the design. What would be the acceptable threshold? And I just based on your opinion or your residents' opinion, would you agree on if it has to be?
You speak up a bit.
On occupancy.
On
occupancy. Yes, I would go with what the chairman, I think, of the last planning committee said, which is the threshold is the difference between it being a single dwelling or anything more than a single dwelling. In other words, the multi-occupancy change of use starts once there are 2 apartments. To do otherwise means that it's very difficult to know where you stop.
You'd have no objection if these were single dwellings, is that right?
Oh, yeah. Yeah,
Sorry, I mentioned it.
okay.
I hope that answers your question.
Yeah, thank you. Okay, thank you very much. Any other questions? Anyone? No. Okay. Well, thank you very much indeed. If I could ask you all to return to your seats in the public gallery. Thank you. So that's helpful listening to the parties there. So colleagues, now it's our turn to ask officers, particularly Carolyn and Lisa Chung, about this. I think perhaps I can make a just very briefly when I was going first, a very quick comment. Obviously, there's a lot of material here. Many of the things I think are really not planning matters. So I think we need to focus our attention on things which are within the orbit of planning, and in particularly planning enforcement. There's lots of other things going on in relation to these boats. So who'd like to go first in asking officers about this? Who'd like to go first?
Well, thank you, Mr. Chairman. I'm going to ask the volume question again, because I believe it's important in getting a sense of how big or not these boats are. And I know you've included details of the lengths of boats, but may I ask you again, do you have an idea of what the internal volume, either in meters cubed or feet cubed, is compared to other comparable boats?
Yeah, I don't have that information, but I think the reason why you're asking it is because it relates to size and what the boat looks like in relation to all the other houseboats on the river. Is that right?
Sorry, I don't think we can hear.
I was saying
Could you
that
repeat? Yeah.
I don't have the volume of the boats, but I think the question is asked because it's the understanding about the size of the boats in relation to the other boats on the river. I think that's the point. Looking at the planning history, so there's no conditions about the design and appearance and size of the houseboats. The use of the land for residential mooring of houseboats is lawful. Intensification relates to these larger boats, but we have to compare it to what can be moored there lawfully as a houseboat. So there are other boats of comparable size. These are the largest, but there is no uniformity of size when considering the houseboats on the river. Some are larger, some are smaller. But there's no fixed design or size that they have to be kept to.
Thank you. And if I may, Mr. Chair, along the second line of questioning, we heard from the applicant that the council's overall financial position is a factor we should consider in terms of enforcement. I think, first of all, a point of information, this council is not under financial strain. But if we were, is that something that we should consider or not?
So the issue about whether to take enforcement action is, as the gentleman said, it's in whether there is harm
Could you
to
speak up? Sorry,
Yeah.
I'm sorry.
Yeah, so
You're
it's-
partly behind a pillar,
Is it
but
harmful?
if you
Is
can
it
try
in
and speak
public
up.
interest? So they're the matters before us, and harm is judged. We would judge that against the development plan. So the policies that I've listed in the report, and then the other material considerations. So a consideration wouldn't be a cost, but it would be the reputational damage to the council were you to sort of take action that was inappropriate, let's say.
And perhaps there's one final question,
Yeah,
if I may,
of course.
Mr. Chair. We heard from Mr. Andrew Prynne about the tests that we have to apply as a committee, the test under section 172, and the concept of Wednesbury unreasonableness. Now, do you agree with the assessment that it is essentially a very low bar under Wednesbury principles, as long as our decision isn't so unreasonable that no reasonable person would consider it reasonable, and then we're entitled to exercise our discretion as a committee. Is that correct or not?
You are entitled to exercise your discretion. It's a planning judgment. So the report before you is officer's opinion on the extent of the harm, but it's before you tonight as committee members to decide in your judgment, is that harm expedient and would it warrant enforcement action? So it's not a requirement to take enforcement action because a breach has been considered to have occurred. It's is it proportionate to take enforcement action? Is it appropriate? It's not. You're not required to, but you must make a decision on whether it's appropriate to, and that rests on the degree of harm. That's what the enforcement regime is based on. Is there harm? What action should be taken, if any, to address it?
There's other questions, Mr. Chairman.
You might like to, Roberta.
Just quickly on your point about the reputation of the council. What do you think? I'd be interested to hear your view. What, if there is any damage? What damage would not take enforcement action when the committee had already decided that there had been a breach due to the council and our reputation, if we're seen to not be enforcing?
So instead, it's a matter of judgment for you tonight to make that decision. My recommendation is that it's not expedient to take enforcement action, and I've given you the reasons why I think it isn't expedient. But that doesn't mean to say that you can't take action. In terms of if you go down that route and enforcement notice is served, then there is the appeal process. So that's a judgment will be made against the council's decision making by the planning inspectorate.
Tim.
Just very quickly, I assume the boats are all covered as part of the Thames Conservation Area, right?
Speak up, please. It's
Sorry, Tim, Matthew.
I believe that the boats are also covered by the Thames Conservation Area. Is that correct?
So the site is located within the Thames Conservation Area.
And is the view from the river part of that protected characteristics?
So yes, it's a view, particularly the gap between the two moorings is something that's in the conservation area appraisal. It's considered desirable to preserve. So these boats nestle amidst the western group of moorings. They don't impact on that cherished gap, if you want to call it that, to this, and it doesn't create a new mooring. That's an important point as well. These boats are moored in existing moorings.
Thank you. I've just got a couple of questions I'd like to ask. If we look at your report, the evaluation, I'm looking in particular at section 8.3, where you say these are the main issues to take account. And in fact, you start with the impact on the Thames Conservation Area, as we've just been discussing. You then move on to the river as a navigable route, local traffic congestion and parking, living conditions of nearby residential properties, waste and housing provision. Now, I'd like your opinion on this point of view. It would seem to me that the principal difficulty here is that I think that if we say that there is an impact on the Thames Conservation Area, that's a factor which you have listed, that you feel we would be entitled to say that enforcement action could be taken on that basis. I think some of the other things going down, I think it would be quite difficult to argue that enforcement could be taken because of them, because of those factors. But am I right in thinking that the decision would be ours, and we might be correct, we might be wrong, but we'd be entitled to do that, wouldn't we?
Yes, you're entitled to do that. This is a recommendation, and you're entitled to make that as a matter of your judgment as committee with tonight.
Yeah. And the second point I'd like to make is about living conditions. Now, if you make the distinction in the report of living conditions of nearby residential properties. Now, somebody who lived quite high up in part of the World's End Estate, who might look out over the river, and they would be looking down on these various boats. I think it would be clear to my mind that these boats do indeed would appear quite substantially larger than the most of the boats that are already there. Can I ask about exactly, and forgive me if this is actually written somewhere and I've overlooked it, but the situation of somebody who lives in a houseboat that was nearby one of these larger boats, and they might feel that they were rather dominated, we engaged in the kind of unusual discussion of whether a houseboat is capable of creating a sense of enclosure, I suppose, is the issue in planning terms. Are you, or Lisa, are you able to help me a bit on that? And do please speak up.
Yes, so you're asking, is it a reasonable judgment to make that the impact of a larger boat may have a harmful impact on the living conditions of somebody living in a boat adjacent to it? I think is your question, isn't it?
Yes.
Yeah, that's a reasonable question, and that's a reasonable consideration. I think in this photograph you can see that the deck is roughly about the same height. The structure above it is slightly higher, but whether that creates a sense of enclosure when you're really looking through those porthole windows, I would say no. They all have views out across the river, it's terraces facing across the river, so they have an open outlook. So that's your choice to make.
And if colleagues will bear with me, I've got a final question, and that is, were we to decide to take enforcement action, we would have to be quite clear as a committee what the planning unit was that we were enforcing against. And it would strike me, were we to go down that route, that it would be necessary to consider the site as a whole. Because if we were trying to consider individual berths, then obviously what we might consider to be an oversized boat could simply move from one berth to another, and we could generate an argument 50-something times.
Yeah.
Is that correct? Am I right in that way of thinking?
If you do decide to take enforcement action tonight, that it should be taken, I should say, then you will have to decide what the planning unit is, and that's another consideration that you'll have to know.
Yes. Good. Colleagues, any other questions to officers? Yeah. Okay, very good. Well, thank you very much indeed. So we need to make a decision here. Well, what do we think? What do we reckon? I've done a lot of talking. Who'd like to go first? Joe.
I'm inclined to go in favour of enforcement. Just looking at that particular picture, for instance, taking into account the conservation area, I realise that you specifically mentioned on the gap, but I think the wider view of conservation area is always taken into account. So if I look here at the river, the only reason why I can see the other side of the river is because of the smaller houseboats in the bigger one that blocks it. And whilst I appreciate that there is a range of sizes, it clearly is the biggest boats in the area at the moment. And I do think we have to draw a line somewhere.
Okay. So that's, you're inclined that way. Other Will?
I would agree with my colleague. I'm also inclined to take enforcement action. I think under the PES section 172, I think we're more than entitled to as a committee. And then when considering paragraph 59, the National Planning Policy Framework, I think there is a real risk that were we not to take enforcement action, we would damage public confidence. And I think it's clear within that paragraph that effective enforcement is important to maintain public confidence. So that's a further reason, Mr. Chairman.
Okay.
Just Chairman, on top of what Councillor Lane said, because if there's no enforcement action, it becomes a habit, and you would see more and more boats intensification. So that's my opinion.
Trying to agree with everything that's been said. I'd just say that I think not enforcing having established there's a breach would be a greater damage to the company reputation than not taking that.
Okay. All right. Well, I think I've got a fair idea of where we might be going. I think before we do make a decision, I think I should just, and again, I'm coming back to paragraph 8.3. Excuse me. 8.3 of the officer's report. The final point 6, Roman 6. I think it is. I think we should remind ourselves that obviously that this situation does create some new homes, and that's on, that is a factor that we should recognise that fact when we make.
It reduces them.
It reduces the rental.
Yeah. Right now, I think what we should do, the correct way of doing this is that we have in front of us an officer report which recommends we take no action. I think, Lorna, I'm looking at you've moved. So the member of the legal department. So I think the way we should do this is that first of all, we should take a vote on the recommendation set out by the officers that we take no action. Is that, and then we see where we go from there.
Yes, let's just take it one step at a time. So
Yes.
we'll vote on the recommendation
All
first.
right. Okay, so the recommendation set out in the report is that we take no action. Can I see those in favour of that as a proposition? Can I see those against? Okay, so that's unanimous that we should take enforcement action. So we now need a resolution to say what we need to decide what the enforcement action should be. I would strongly suggest that we don't attempt to draft an enforcement notice ourselves, that must be left to officers. However, I think it's important that we are quite clear what we are asking officers to do. Okay, so I would suggest, first of all, that that the issue of the planning unit, that we say that it is the whole site. Okay, that's the first point. I would suggest, colleagues, the principal reason is the impact on the Thames conservation area. I think that's the principal factor. I don't know how colleagues feel about the impact on living conditions of nearby residents who look down on the property or who live immediately nearby.
Chairman, I strongly support the the living conditions as well.
Okay.
Is that my?
Yes.
I think there's some merit to that, although I'm minded to agree with you, Chairman, that actually Roman numeral 1 is certainly the most important reason. I do think if we do consider living conditions, actually the point that was made about those with protected characteristics under the ECHR is perhaps something else that could feed into that point as well.
Okay. Well, I think on balance, it sounds as though we're probably in favour of making that that would be a second reason why we would wish to take enforcement action.
So is that the impact on the living conditions? Whose living conditions? Sorry.
Well, I think it would be. I think it would be both. It would be people living in nearby property where they look down onto these much larger boats, but also I think also those who have to are berthed immediately by them. So I think that's we would be saying that. I think the final point I should raise with colleagues, I think in terms of an enforcement notice always has to give some kind of time scale. Now, I think we have to clearly these boats exist, and we don't know who's actually living on them at the moment. So I think probably we have to be on the side of generosity here. I think, for example, if we were to demand that they be moved within 1 month or something, that would probably be unreasonable.
Chairman, sorry to interrupt. That is something I think that should be delegated to officers to pursue, because there's going to have to be some sort of assessment of who is living on the boats and how easy it is to find somewhere else to live. I think what the officers need is what you've clarified the planning unit. That's great. And you clarified the harm, the policy reasons for taking enforcement action, except with regards to living conditions, it needs to be clarified, because living conditions are things like loss of privacy, overlooking, that sort of thing. So it's presumably it's the people either side, or I mean,
yes, I mean, I think following my earlier conversation, I would suggest that it would be a sense of enclosure of someone living on a boat that found a much larger boat, immediately next to them. I think,
So it's the immediate neighbours, really.
yes,
On both sides.
yes, yes.
If I can
Yeah,
just
yeah.
follow on from that. So you mentioned living conditions of those living on the houseboats and that sensitive enclosure, but you also mentioned those that look down on it. If I could refer you to the site plan that's in the pack,
Yes,
we do need to be precise on this matter. To the point that we do need to identify the harm to those properties. So you need to identify exact addresses as such. But is there a particular part or location that you are concerned about, and then what that harm is to the people living there?
well, I think it completely, to my mind, it would change the nature of the outlook over the river, and that is in turn, I mean, all of these things are all linked together in terms of the conservation area.
So Lisa, you don't have to link the harm to the Roman number 4 living conditions. You can link that to number 1.
Number 1 being the impact on the conservation area.
Yeah, exactly. You don't have to link that to number 4.
No, but if you're talking about living conditions,
Living conditions on either side
yeah.
because of one thing,
So
but the harm, you don't have to link that with the living conditions. That's
if that's what the committee wants to say, but earlier on there was a discussion around those living potentially on the Wells End estate looking down. So that's the point I want to capture. Is that part of the consideration for you? Or actually, would you like to focus on those living in neighbouring houseboats and then the impact on the conservation area?
Well, the conservation area is number 1. Those living on neighbouring houseboats is number 2. And then I get the sense that on balance, we think those living nearby, and I'm citing the World's End estate because obviously that's an example of properties where a large number of people are much higher up, and the concept of looking down to seeing the houseboats area below them and changing the aspect of the conservation area from their perspective.
so the appearance tracking.
That really goes into number 1.
Number
isn't it?
1, yeah, that's what I'm saying. You have to link that to number 4.
All right.
What do you think?
I think so.
Well, so you're talking about as part of number 1, it'd be views of the river and views of the boats themselves.
Yeah.
Okay. Well, I think sorry everyone for
No, you've got to get it.
yeah, members of the public in particular. Clearly, we have to have this sort of rather elaborate discussion because we have to be quite clear about what it is and is not that we're doing, and what we feel we can do. So thank you for bearing with us. So I think the conclusion of this is that the resolution that we need to consider to take enforcement action would be based, it would be delegated to officers to draw that up, but it would be based around the harm to the Thames Conservation Area and the living conditions of the residents of neighbouring houseboats who would be most impacted.
Yes, I think that's correct, Chairman, and I think as was discussed in relation to Roman numeral 4, the living conditions, that is the adjacent houseboats.
Visually, it's right.
Yeah,
Exactly.
Yes. And the only other thing that you have to steer officers is in relation to the steps for compliance, because presumably that would just be removing those 3 houseboats. Because that's what would be needed to address the harm. So
If I may, Chairman, just on the point about the timescale for enforcement, I recognise the arguments on both sides, perhaps in terms of delegation, but I'm concerned that if the committee gives no guidance at all, then perhaps that could be a rather longer period of time than we would expect. So I'm conscious of perhaps providing, even if it's not totally prescriptive, of giving some indication on what we would like.
yes, it's difficult because the assessment hasn't been done on human rights, because everybody has human rights, and the Equalities Act that we've been, that was mentioned. There is an assessment that needs to be done, which hasn't been done yet, with regards to the occupants of the 3 houseboats. So it's difficult tonight to put a time scale on it. It's probably just something, I mean, I don't know if you agree, Lisa.
Well, I mean, we've had conversations prior to the meeting, Carolyn and I, and we did discuss around 9 months.
9
Being around. Now, of course, you do need to go through the correct procedures. And people are living on those.
They're rented, they're very expensive rents.
No, I think that, please, don't interrupt. Please do not. Well, I think members of the committee, I think we instinctively feel 9 months is we think that is obviously sounds too long. But I hear what the legal advice is, that there are this is a formal process that we can't do at a committee table. But I think officers have very much heard our discussion. They know what's been said, and I think they'll take that. Yeah, obviously we'll take that on board. Yes. So we need to conclude this, and the conclusion is that we must have a resolution to take enforcement action. I'm happy to propose. Who would like to second? Councillor Lane seconds. So that is to take enforcement action for all of the reasons that we have just discussed at considerable length. So, Ms. Boundary, you're happy that we go ahead and have a vote on that basis? Yes. Okay, so the resolution is to take enforcement action. Can I see those in favour of that course, take enforcement action? Those against, there are none, so that's unanimous as well. Thank you very much. Thank you. If you have come for this item, please do feel free to leave now, because in a short time, we will have to move on down the agenda. Thank you. Yes, no, exactly. No, absolutely.
But we will make all of them.
I'm not very sure why. Thank you very much.
Oh, yeah, response.
Yeah, definitely. Go through that.
They're all at everyone except Tories.
You done just
These are
Okay, thank you very much indeed. So we'll now move on to consider the condition application for Durham Place. And Lisa Chung is going to introduce this. Lisa.
Thank you, Chairman. I've only got the one slide for you this evening, but just for a bit of background to this application, you may have noticed it's a couple of years old. At the back end of 2022-3, Durham Place, which you can just see to the right, number 4, partially collapsed in the night, and other properties along that stretch were affected as a result of that. Shortly after, the council's dangerous structures team served a dangerous structures notice on 2-3 because it collapsed, and also served a neglected structures notice on number 4, which had been empty for some time, had planning permission to do various works that you can see in the planning history, but clearly shares a party wall on 2 and 3. Now, if you refer to the addendum, I've just made a correction because I had said in the report that the dangerous structures notice had applied to number 4. It's actually 2-3, but then neglected structures notice on number 4. Essentially, the powers are the same and the requirements are the same, which is get on and do the works as soon as you can, bring the properties back into use, and obviously deal with the issues around the structures being dangerous. What that meant is that number 4 proceeded to do its various works without having submitted details of its conditions, including the condition for the CTMP. Essentially, it's been operating for about 2 years with a CTMP in place, but that CTMP has not been approved, and it's with you this evening. Now, the reason it's taken so long is there has been some changes made to that document, as well as consultation with neighbours, to ensure that obviously the document is fit for purpose. Now, the sites have been operated, so 2 and 3 is under construction, so is 4 and so is 5 and 6. So you can imagine that if not properly managed, it could be somewhat chaotic. But the plan before you just shows the current arrangements. Now, essentially, they've each got their own separate plan, but they do work with each other, and you can see that they're sharing spaces with regards to parking suspensions to accommodate loading for larger loads. The recommendation is that the CTMP is sufficient, it meets the requirements of the condition, and the committee should be minded to grant that this evening. That's it.
Thank you. Are there any questions about this?
Just so the CTMP, the new proposal, has been.
Yeah, so this CTMP by and large has been in operation for nearly 2 years. We made some amendments because as they're approaching the latter stages of the construction, they were considering keeping 3 skip placements on the highway. Obviously, as construction goes on, you don't need that amount of skips. It should reduce as you go through the programme. So one of the changes we've got was, you can see the red box just in front of the orange box is the proposed location for the skip. So we reduced from 3 to 1. So it's those sorts of changes that are just taking into account the way in which a construction takes place over time.
In that case, I think we can make a decision. So the recommendation is that we grant approval of discharge of condition. Can I see those in favour, please? So that is agreed. Thank you. If we can now move to the north, and we have 2 applications relating to 1 Carmel Court. Now, these are actually for, although it's the same one property, that they actually relate to different development. So I think we're going to take the order, them in the order in which they appear in the pack. So Alice, you're going to introduce this. So we will first consider the application 23/07598. So would you like to introduce that when you're ready?
Great, thank you, Chairman. So the application before members this evening relates to number 1 Carmel Court, and that's indeed being identified by the red arrow on the slide. As mentioned by Councillor Husband, there are 2 applications before members this evening. The first application relates to some alterations at roof level and to the rear. So this is the first application which I'm going to present and is going to be considered. So the existing front and the proposed front elevation can be seen on this slide. The red arrow denotes the application and the red marking on the left-hand image includes the demolition of those front railings and the existing access hatch to the roof. The existing rear and the proposed rear elevation can be seen here. Again, the left-hand image with the red arrow is the application property, and the openings at the lower ground floor level outlined in the red are to be demolished. And the proposed rear elevation is on the right-hand side, where members can note the additional openings at the first and second floor level and the openings at the ground and lower ground floor level here. Members can also note the alteration to the extension of the boundary or the balustrading at roof level and the new access hatch, which has been repositioned to this location here. This is the existing and proposed roof plan. The application also includes the addition of the air source heat pump, which has been sited at roof level. That is, if I indicate with my cursor, is located by the chimney breast in this location here. The existing sections can be seen on this slide. Again, the red denotes the demolition, and so members can note some internal works that are being demolished. The existing roof hatch at roof level and the rear openings here. And then some proposed sections just to show those location of the new openings on the back and the alterations to the roof access. These are some site photographs. So the image on the left-hand side is the front entrance to the application property. Members may have noted from the officer report that it is adjoined on the northern side by number 2, and that does include similar railings at roof level that members can see in this photograph here. The photo on the right-hand side is taken from the existing opening on the rear elevation, which currently serves a bathroom in the application site, and that looks out onto the properties to the rear on Holland Place. These photos are taken from the roof of the building, so again, members can note the roof of the properties to Holland Place to the back. On the very right-hand image is the chimney breast and where the AC unit would be sited closely adjacent to this. That concludes my presentation this evening. Officer's recommendation is to grant planning permission subject to the conditions set out within the officer's report, and noting the additional representation received in the addendum report as well. Thank you.
Thank you. Can I ask the objectors who are neighbours, please, if you can come forward and join us at the table. When you're ready, please, you've got up to 3 minutes shared amongst us, so please go.
First, we are concerned with the impact of this application on the conservation area. Our expert heritage consultant, Claire Gale, will deal with this issue. Second, the application will have an unacceptable impact on the living conditions that we and our neighbours currently enjoy. The proposals are directly contrary to the requirements of local plan policy CF5. We are very concerned by the noise that the proposed air source heat pump will generate. We commissioned our own acoustics report to review the report submitted by the applicant. This concluded that the submitted noise assessment was deficient as it had significantly understated the actual background noise level at the site by some 6 decibels. This is a very significant difference, which means that the noise level of the air source heat pump would therefore have to be limited to 23 decibels and not 29 decibels. The council has not responded to our acoustics report, and we're very concerned that this issue has not been properly addressed in the director's report before you. The applicant has not shown that when the actual background noise levels are properly considered, that the proposed mitigation strategy will be effective. The consequence of this under-assessment is that there is no information to enable you to fairly conclude that the mitigation strategy proposed by the applicant is satisfactory. Whilst officers rely on condition 3, the reality is there is no guarantee that this condition is capable of being discharged against the actual background noise levels as assessed by our report. Concerning the proposed roof terrace, it's never been used as a roof terrace for 30 years since I've lived here. The proposed railings, there are no railings currently. Proposed railings, the roof terrace would create more intrusive overlooking, loss of privacy and noise. The applicant must at least recess the railings by 1 meter.
The application site lies within the boundaries of the Kensington Conservation Area and adjacent to listed buildings. A heritage statement should have been submitted which assessed the significance of these heritage assets as per paragraph 200 of the NPPF to aid with the general duty imposed on the council under sections 66 and 72 of the Planning, Listed Buildings and Conservation Areas Act 1990. This is also a validation requirement RVKC, yet the application was validated without one and when it should not have been. Secondly, the submission is lacking in information required to assess the impact of the proposals on the significance of the historic environment, including details of materials of the acoustic enclosure and the windows. This information is critical in understanding the acceptability of the proposals in this historic context. Notwithstanding the lack of sufficient information within the submission, the site is a typical example of Victorian workers' housing, demonstrated by the backland position, the simple appearance of the frontage, and the lack of fenestration of the rear elevation. The incorporation of fenestration to the rear elevation will fundamentally alter the character and integrity of the building, and subsequently its contribution to the surrounding conservation area. The acceptability of this element of the proposal should be therefore reassessed by the committee. Finally, the incorporation of the air source heat pump and an acoustic enclosure of an uncertain size, as well as the considerably enlarged roof access, result in visible new additions to the historic roofscape, creating more bulk in the context of the historic slender chimney stack, both public and private use.
Thank you. Thank you very much indeed. So if you remain in your seats, is David Tigg of the architect, please you join us. Perhaps that seat just there, those 20 years. So in similar fashion, please, when you're ready, you've got well, just fractionally over 3 minutes. So please go ahead.
Well, first of all, evening, councillors. This it probably won't be new to you, obviously, in a simple sense. This application is the third time it's been in front of you guys, and twice before it's already been approved. Slightly separate kind of matters it's covering, but ultimately very much the same house, the same principles of design. The issues here are kind of actually a very, very modest set of reorganisation of a modest house, obviously, yes, within a conservation area, but done in a very sympathetic and traditional way. You know, the back of the building, to come to the initial point about window sizes, are very modest again. They are done in, as described on the drawings, sliding sash windows, again, very traditional, very simple kind of window openings. And everything we're doing actually, and we have a significant history of working within the borough, is of a modest scale and of a modest nature that actually sits very, very well within the conforms of where it is, the environment that it's in. The other kind of obviously key part of this is obviously a renovation to an existing house for a family. And the building is now in such a state that actually all the ceilings are falling down. Rain is falling actually now within it, but we haven't been actually able to get to a point where we're actually able to actually implement any kind of serious work to the overall property. What we'd like to do, obviously, as part of that renovation, is to upgrade not only the thermal fabric of the building, but also its energy use. And obviously, that's compelled both you guys as a borough, but also nationally, to make sure that actually everything we're doing is efficient and as efficient as possible, so that this generation, every future generation, that we're using the best possible ways to actually heat and use energy for our homes. So hence, the use of an SLC pump isn't destroyed by any means. In fact, it's for the general kind of promoted. How we're then dealing with that is obviously via acoustic kind of enclosures. Again, if something's done all over the borough, it's done all over the sort of London, all over the country. And it's for us then to obviously make sure it combines as it should do with your policy. Now, we've done obviously a acoustic test with professionals, and they've kind of set out the criteria of how to achieve that goal. And obviously, that you set thresholds, and we will sort of achieve them, and that is something we can do. So, in a simple sense, this is a very simple set of applications. We're making very, very modest alterations to our house, and within that overall renovation sense, there's nothing we're doing here which we feel should warrant anything other than a positive response from you guys in terms of us moving forward to create a family home. What I'll say.
Okay, thank you very much. So, colleagues, questions. Arian, would you like to go first?
Thanks, Chairman. Question to the objectors. I know you raised the point about the noise from the blue pump. First question is, I understand you're one to Holland. Yeah. One roughly about how far would that be from the existing site? Second thing, I understand you said 0.9 decibels to be decreased to 23, sorry. Based on the government regulations, I think the decibels is about 42 decibels. The acceptable noise from the heat pump is about 43 decibels. So yeah, maybe you could do step by step.
Okay, we're about 4 or 5 meters away. It's very close.
You can see that actually on the plan.
We're just
do you have a cursor where you point to that?
Okay, which is very close. And the council's own guidelines say that any equipment, noise equipment, has to be 10 decibel below the actual background noise level. And the background noise level we measured at night is 33 decibels. So by the council's own guidelines, the limit is 23. And the applicant has measured 39. And we've measured 33. So the applicant would want 29, but we want 23 because the actual background noise level is 6 decibels lower than what they measured. And we measured over 3 nights, they only measured for 1 night. And we've repeatedly submitted the acoustic report, we've uploaded it in time, we sent it again this morning, but no one takes our report.
I'll ask that question to the officer. Any contact? Yeah, sorry.
I suppose the other thing is, you see, they operate day and night, so that's the crux of their source heat pump. Yes, they are efficient, but this model is also quite an outdated model that they've proposed. They have never updated their application, and I think there might be newer or better models on the market that might do this more sensitively, but since we've never engaged with us, we don't really know.
So would you be satisfied if there's a new heat pump that would meet your
Noise reduction?
any counter answer?
Well, I mean, I think from our perspective, yeah, we obviously just want, I'm an architect, not an M&E engineer, but fundamentally speaking, the principle is that our client really just wants to actually use air source heat pumps, so, rather than sort of old school kind of boilers or anything else. And actually, obviously, we're just here to make sure it complies with, the requirements of the borough. We're very happy to do that. It's very simple. It doesn't need to be an overblown matter at all. Obviously use acoustic engineers to test things. Obviously these guys have as well. There are obviously some discussions around very, very relatively more technical matters, but I don't think anyone's objecting in principle as I see it as to actually the principle of using an air source heat pump and filming acoustic exposed around it. The end. And that is, as long as it satisfies you as a borough, that's how it should be.
I've got a question actually to gentleman who's an objector. You rightly point out you're in close proximity to this building. The proposed condition 8 for the new rear windows actually has them fixed shut and obscure glaze up to 1.7 meters. Would you not see that as something that was really quite useful, given that the existing situation is that there is overlooking? Okay, you may have been used to having a vacant building that you looked out on, but would you not take the point that that is helpful?
Yes, it is. It's just then I think it goes against the heritage of the building, which it's basically creating a different. You're destroying the history of the place, and I think that's a great shame.
But also, if I may, if they, yes, we are looking at most of it. We're looking at a brick wall, so our house has been sort of encroached upon by buildings over time, and those are the only windows that actually, at least partially, have an unobstructed or not overlooked view. So as you can see from the previous image where they can the bathroom window, the existing openings are at quite an angle. So I think having them glazed helps. But it is still, overlooking sort of directly would be like living in Goldfish Gulch. But yes, and is not. It is quite a strong sense of loss of privacy, which is why also I think wherever you come out on the roof terrace, I think having the railings recessed at the back would afford a greater sense of privacy, because otherwise it really is looking directly into a goldfish bowl for us.
Well, thank you, Chair. And just a couple of questions for the applicants. The first question, the heat pump enclosure, bearing in mind we're in a conservation area, the heritage of the building, I can ask, what will the exterior be made out of? Will it be brick matching the existing building, or will it be something else?
It'll be an acoustic liver, because obviously it has to sort of be able to ventilate through it, and actually, but then stop noise coming out of the way. So you have to get airflow through it. So it's sort of a layered system ultimately.
What does it look like? What's it?
So it's a kind of a metal, typically. You can kind of then clad that over again with a timber kind of balustrade onto it. But the fundamental nature of an acoustic, you're asking what the technical thing is, that usually it's a sort of a metal enclosure that sort of prevents noise but allows air to sort of pass through effectively a box.
Okay, and my second question, and perhaps Ms. Colbert, could we go back a couple of slides to the railings on not that one, but there was a photograph of a couple of railings on existing buildings. Maybe one more back. Yes, that's perfect. So, Mr. Tigg, you can see the railings on the existing building. They're sort of rather ornate, and you have a style of this sort of circles and the sort of top fifth. No. What will the railings you're proposing?
Like to flow like as the conservation, like it's a black metal railing, kind of very simple. Very much. I mean, we're sort of saying it's like kind of to the top, top left of the picture. I know it's not very clear, but then I think there's a sort of a balustrade along that line. It's because when you're reading this sort of. This is a little mini terrace, so the idea would be that it would just be a sort of a lovely sort of continuation of that black metal railing that kind of comes along. Yeah,
I think it would be helpful considering if it's a conservation area, railings could match existing.
It is. Sorry, I'm saying it's matching existing. Okay. It's that.
Okay. Perfect.
Zoom in on
that was what I wanted.
Yeah.
Okay, thank you.
By the way, sorry, just for clarification, I think this point raised about being a roof terrace. We're not asking for a roof terrace, are there? It needs a sensitive enclosure to be able to like access it and everything else, but there isn't an actual, like, we're not saying you could like the roof terrace. Be absolutely clear.
Thank you.
Yeah.
Any other questions? Okay, thank you very much. If you return to your seats, I know you're going to be back again shortly, but if you don't mind, if you can just take the seat. Yes, that's fine. Okay, so questions to officers here. Anyone like to ask? Tim first and then Arian.
I have a very quick question because we just heard from the applicants that the roof is not going to be used as a terrace. But if I understand correctly from the conditions, number 7, there is a roof terrace condition on that with no tall items. Can it therefore be used as a roof terrace as a result of that condition or not?
Thank you for your question. So the conditions recommended by us at the moment, you're correct, do refer to no tall items, and there isn't a condition precluding the use of that roof as a terrace. As mentioned in section 6.8 of my officer's report, when we're discussing living conditions, there's already an existing roof access, which I've shown as part of some photos. So there's already access to that roof, and it could be used as a roof terrace now, and there would be no change by way of introducing the railings would allow it for it to be maintained and potentially accessed as a roof terrace. But when considering the existing use or what potentially could be used compared to what's proposed, there's no change. And officers have considered that the use of it as a terrace, should it be used for amenity space, or the continued use of it as amenity space, is acceptable.
To follow up on that, because what you saw in the picture previously, obviously that is not being used as a terrace now. And what I from understand from the objectors hasn't been used as a terrace in a very long time. Also, the applicant is not looking to use it as a roof terrace, which I find very interesting. Are there existing roof terraces as part of the area in the nearby vicinity?
So from my officer site photos, and I'm just going to go back to the aerial imaging, there is a railing and balustrading at number 2, which is located to the north hand side. I believe that's being used as a terrace, but I wouldn't like to confirm that to members this evening, just because I haven't seen whether it was granted by way of planning application or whether it's been there for some time. There is also what looks to be a terrace located at this property here to the rear. But again, I haven't looked into the history of that, but I think we potentially can see it in one of these photos. But I wouldn't like to confirm something, so that definitely is a terrace, because I haven't obviously cited it as part of my report or captured it in my photos.
Arian.
Thanks, Jim. In terms of the decibels, the noise thing, you might not have the answer, but is there a regulation or a advisory limit?
Yes, so members may find, and with many applications in the borough, with any kind of external services or vents, we do look to control the noise emitted from those by the way of planning conditions. So if I draw members' attention to condition 3 and condition 4, so condition 3 controls the noise that would be emitted from that air source heat pump, and then condition 4 requires it to be supported on an anti-vibration mount. And if at any time the plant isn't adhering to that condition, then it should be switched off until such time it may be repaired or replaced, so it can continue to comply with that condition. So the condition is what the council would use to control the noise emitted from the plant.
Would we, as an authority, make that test before? Do we take a report from the installed?
Yeah, correct. So in line with the adopted noise supplementary plan of document, a noise report should be submitted for any applications which involve external plants such as air source heat pumps. This application has been supported by a noise report that has been reviewed by the council's environmental health team, and they've found it to comply or show compliance with the noise SPD subject to these conditions.
Just two hopefully quick ones. Just on the roof terrace point, really the applicant has said they don't intend to use it as a roof terrace. We not had a condition that it's not to be used as a roof terrace.
Members could look at whether a condition could be used, and what I would suggest from an officer's point of view, it might not meet all of the tests of what a condition needs to be, in that they could use it as a roof terrace at the moment, and there isn't a change. So I would just ask members to be mindful of the tests that conditions need to meet when attaching them.
And just then secondly, just on the acoustic, obviously you've had a concern that their report is something different. Is there anything to be done from our end to just to, if we were to approve it, trying to allay some of their concerns, tighten it up a little bit more?
So the noise report, which the objectors have referenced this afternoon, I know that it was mentioned that they were sent across this morning. I haven't received that in my inbox too, but it has been received as part of the application, and it has been referenced as part of 8 of the responses captured in 8.2 subsection 2. And so it has been received by myself and kind of referenced as part of that section of my report. In terms of strengthening it, the condition and the decibels and kind of the limits set out in condition 3 comply with what's acceptable in terms of our noise supplementary planning document and the relevant policies, and subject to the air source heat pump complying with that condition, it wouldn't have an adverse impact in terms of disturbance to nearby residents. And so I wouldn't necessarily recommend that there's kind of a lowering of those levels, because that's kind of the limit that's been agreed as part of that SPD and found to be acceptable.
It's 8.2 subsection 2 doesn't seem to really respond to what their piece of report finds. So it says that the applicant report is taken at face value and is satisfactory. It doesn't really compare with the private one. So I'm just wondering if even, I know you said it's not necessarily necessary, but if there was just something that could be done as a sort of safeguarding.
Yeah, just to add on topic you about it. I know we took the report from the applicant.
Yeah.
We're not counter check that, not the report, but just check the physical. That's something that we could do.
So the noise report that's been provided by the applicant in support of the application has been reviewed by officers and also by the environmental health team and found to be acceptable. What members may or could look to do is to either look to potentially add an additional part to condition 3, so that written confirmation of the noise of the plant when it's installed, meeting those requirements is provided to the local planning authority. That could add that kind of second step to ensure that it complies with those levels and that they can write to us to say that it complies. But that's all I can think of.
Questions? Okay. Well, we make that. I think. Yeah, I mean, it is. I can imagine that this location at night would be very, very frighteningly. So I think if it's feasible to slightly amend condition 3 as Alice Culver has just discussed, I think that would be helpful. We generally go along with that. I think in terms of the roof terrace, I think we've got no tall items. It's condition 7. I mean, certainly in this location, if tall items, if this roof is used for maintenance, and there's no need to put up tall items, is there? So it seems to me, I mean, they would be extremely conspicuous, I think, in this location. So I think that's probably reasonable. So
given that it hasn't been used as a roof terrace for a very long time, doesn't then also like with things that have been changed without planning permission after 10 years, you can't enforce those anymore. Doesn't that also work the other way around, where something that hasn't been used for 10 years?
Yeah, no, I think it's a good point. What's the answer to that?
Yeah. Pardon me. So the use of the roof as an amenity space or as a terrace, the use in itself, when you consider it in that it would remain as a single residential property, there would be no material change of use by way of using that as an amenity space. So that the use of the roof for a terrace or an amenity area wouldn't in itself require planning permission for the use. What usually requires planning permission is the associated railings or balustrading to facilitate that use. So hopefully that clarifies in terms of the years, but for them to access that roof and use it as a terrace in itself wouldn't be a material change of use that would require planning permission.
No, what and I appreciate that. What for me, the conclusion from that then also is it does create a potential for overlooking if they do start to use it as a roof terrace to the nearby properties, which previously was not there, similar to the windows basically.
So I think from what the stance that officers did reference as part of the report is that the existing roof has the access hatch which allows access onto it. It does have some railings at the front and then kind of a wooden railing at the back, which I can show you on my photos. So when you consider that it could be accessed and used as a terrace, should the applicants wish to in its current form, then when you compare the existing to the proposed, there would be no material harm by way of that. But that is for members to make that judgment.
Is there a railing all the way around?
So not currently. So the application seeks to extend that railing to the rear.
Would be that would encourage use as a roof terrace. You wouldn't necessarily now go and sit with your legs dangling off and have a pint. Whereas if you put up a railing, you could have a little stool and go and sit there. So I guess, I just think given that the applicant has said they're not intending to, hopefully they won't, it shouldn't be a harm to them. I would feel more comfortable with that condition. Just be my point.
Yeah, so if members wish to include a condition,
if we can.
I would just,
All right. Okay, I think we need to make a decision. So I'm picking up a clear signal that if we can preclude use as a roof terrace, then we would wish to do so. Presumably on that basis, condition 7 falls by the way, because that would be struck as yes.
You could either add, so you could add a new condition to preclude the use of the roof as a terrace, and should that condition, as you say, number 7, no longer be needed, then you could remove that and then feel that it's necessary.
I think that's probably. I think having a new condition precluding uses of the roof as a terrace. I think if we can do that, then I think I get the distinct impression that would be supported by colleagues.
If I may, just to avoid any confusion, but I would suggest that we amend condition 6 to remove reference to terrace or roof railings. And that railings to the roof shall be painted black.
Yeah.
No point calling it a terrace if you then got not.
That's another.
Just completely.
No, you're quite right. That's another change that we would need to make. Okay, so if we make so we talked about roof terrace. So we're precluding roof terrace use. We're adding an additional part to condition 3, which relates to the sound of this air source heat pump with its enclosure. If we make with those amendments to the conditions, the recommendation is to grant. Can I see those in favour, please, of that? Okay, so that is agreed, but with those amendments, as we have discussed. Thank you very much indeed. If we now move on to the second application relating to the same property, and Alice, you're going to introduce this as well.
Correct. Thank you, Chairman. Firstly, I would draw members' attention to the addendum report. There's been an additional representation received and there's some alterations to the officers' report as well. So again, the application for members relates to number 1, Carmel Court, which again can be seen identified by the red arrow on the slide before members. The existing property benefits from or has a ground floor and a lower ground floor, and that can be seen on the slide with the existing ground floor on the left-hand side and the proposed the existing lower ground floor on the right-hand side, sorry. The existing sections can be seen on this slide. As referenced as part of the officer report, there are different levels across the site which can be seen on this section. I would draw members' attention to the rear of the site in the rear courtyard or garden area, if I just move my cursor here, where, as referenced as part of the report, officers have considered the prevailing ground level of the site to be. Members can note the existing lower ground floor in this location here on this section. So the application to the board members this evening is a lateral extension of the lower ground floor level. And this is the proposed lower ground floor plan, which will provide a kitchen and dining area. So the area indicated by the green is the existing lower ground floor, and members can note that lateral extension or the addition just where my cursor is here. And then this can be seen in section form here. So these are the proposed sections. I would just draw members' attention to their pack. It has been provided as part of the officer's report, but the green colouring on the bottom image isn't so clear in your pack in the printed yellow paper. But it is provided again in your selection of drawings at the back as well. It's just, just this green line here shows the existing lower ground floor level. So these are just some site photos. So the existing rear courtyard or garden area can be seen on the left-hand side. And then this is the stairs which leads down to the lower ground floor on the right. And then this is some photos of the existing lower ground floor level. And members can note the windows which face onto the rear courtyard or garden area as referenced as part of the officer's report. And then lastly, this is a photo of that front fold. Sorry, it's a little bit dark, but that is at the lower ground floor level as well. That concludes my presentation. The recommendation before members this evening is to grant planning permission and subject to the recommended conditions. Thank you.
Thank you very much. If I could ask the objectors to this application, please come back to the table and join us again. So please.
I think the sections were quite helpful to visualize it. So I don't know.
Yes, thank you. So when you're ready, please go ahead and 3 minutes shared as before.
We consider that the council would be in error by not considering this basement development and testing it against the requirements outlined in policy CL7, which is a very comprehensive policy, and it provides important safeguards for all neighbouring buildings in this very built-up part of the conservation area. It also would allow you to, the statutory duty is to apply the local plan unless there are material considerations to the contrary. The proposed increase in that basement or lower ground floor level of around 13 square metres constitutes a large portion of the existing lower ground floor level. All of this newly created space is to the west of the application, so to the front, and below the level of the pavement. The vault and the surrounding area, as well as half of the existing floor space, is not currently of habitable proportions, ranging from approximately 130 metres to 180 metres in ceiling height. And actually, but for the lowering of the existing ground floor level and digging foundations below this, it wouldn't be possible to have one lateral unit of habitable space. If you're standing at the front, you would dig down 3 metres from the ground level. And if you're standing in the rear garden, I think nearly sort of 2.5 if you go to the foundations. The officer has measured it at 1.94 metres below the rear garden level. If you take it all the way to the front, which is a step lower, you add 10 centimetres or so to the floor level. So it's a significant amount of excavation. The front should be the prevailing level, we think, both in terms of being closer to the maximum volume of excavation, as well as the relevant site in this important historic conservation area, the relevant facade is the front. The report says that policy CL7 is not engaged, to quote from paragraph 6.19, a new story of accommodation is not being created. Having taken legal advice on this, we would be grateful for clarification as to the officer's interpretation of policy CL7. So it's a very simple question. Is the officer advising the committee that policy CL7 cannot be engaged unless the works being proposed would create a new story of development, all of which would be below the prevailing ground level at the site in question? I would also like to hand over to my colleague for the heritage aspect.
Okay.
No information has been.
About 30 seconds left.
Okay.
So.
The depth of proposals have the potential to wholly alter the footings of the historic building altogether, which could have significant structural implications on the host building and the listed buildings which are immediately adjacent to the site, particularly considering the historic and extremely dense urban grain of the immediate area. An application for basement development with this level of excavation in this context should provide a sufficient level of detail to understand the physical impacts and proposed mitigation strategies. At this stage, we believe the submission does not comprise enough information to fully alleviate these concerns and should be refused on this basis.
Thank you very much. So, Mr. Tick, if you can come back and join us at the.
Could I stand up here? Is that possible?
No, I think it would be better if you don't mind if we can. But we can.
I understand, because actually I'm interested in pick up some.
You can ask for particular slides if you wish. So okay.
Can I go?
Yes, please. Go ahead.
Third time lucky, I think, getting here. What is effectively a very, very modest area of excavation to an existing level of a house, which is currently a kitchen. You can stand in there. Any of you guys can go down there. It works as a kind of set of rooms. The photos sort of show it for itself. It isn't fantastic by any means, but it is a lower ground floor, and it exists as such. I guess daylight from a garden. So that kind of underpins the sort of principle of habitable floor. It exists. Can be used as such and has been used historically. Because we've been hanging around a rather long time to get planned. The second point here is that actually, in terms of the actual level of work we're doing, just to give you the actual real scale of it, That is about 1.65. We're talking about a width that's probably another 10 or 15 centimeters wider than my arm reach of actual work we're doing to, continue this sort of lower ground floor. So actually, in terms of volume of area, my height, by my kind of width, in terms of you stretch it across the actual width, probably is sort of approximately gives you a sense of the real scale of the works we're doing. So in reality, this is very small scale kind of levels of kind of excavation and removal of soil and all these kind of things. And in terms of actually the overall proposals, well, as a company, we've done vast amounts of these sort of types of projects. And actually, this is, as I say, extraordinarily modest in terms of the existing building and to the points of our sort of conservation. Doing these types of works can be done very safely, very efficiently, very, very straightforwardly, and actually to no detriment to the building whatsoever. And as a result, we feel that actually what we're doing here is creating an extraordinarily modest kitchen, a very small kitchen that can be on a lower ground floor, can enjoy daylight, and then you can use the rest of the home as just a simple family home. So ultimately, what I'm really kind of in conclusion here is that we've followed everything that we need to do policy in terms of discussions, pre-applications, everything through to then actually kind of come forward with what is an extraordinarily modest set of proposals to make it habitable, a good place to live, and can be conjoined into sort of the upper now approved application to actually make a good, sensible place for someone, a family to live in at the end.
Thank you very much. Colleagues, questions? Harry, do you want to go first?
Question for the objectives. Your main concern is that they should have triggered seal policy 7, basement policy. And that's your main objection because the opposite thing that's not, it doesn't fall under seal policy. Let me get clarity from the officers so then I have more questions on that. Thank you.
Okay, yeah, I mean, we will obviously pursue these points with officers, definitely. Who else would like to ask a question?
May I just, sure. Yes, that is my main objection, but my point is also that actually, I think they can build exactly what they want to build. I don't want to stop them building. They can build exactly what they want to build if you apply policy CL7. It makes no difference to their plan. They can realise it exactly as they've proposed it. But what CL7 does, given the concern that other people in the community have expressed about the building, is it offers additional safeguards. They have to provide some additional reports, a heritage report. They have to provide management strategies. They have to engage. So actually, I think it would benefit everybody wins. They can build it, and the neighbours can sleep more peacefully knowing that it's within the confines of CL7.
Yeah, sure. Some of the policies actually have already been part of the actual, even though it doesn't go to the sort of the nth degree, given the size of what we're talking about, but actually CTMP has been produced. Various other kind of aspects have been considered, and obviously there's been very thorough such as structural design and everything else that we are very familiar with sort of work very well within the complex program.
You're not thinking the existing one, you're just extending towards.
Yeah, I mean the green line indicating the drawing probably indicates it best. It's really kind of like the existing, yeah, this is a great plan. This sort of indicates where we are. So you've got like a little WC, which would be in sort of box area. And then obviously then, as I say, my arm's width, literally this sort of type of size of sort of basically create a kitchen unit from here to here and a little bit of space for someone to kind of walk. And then you can put a kitchen table here. So it's very, very modest in terms of scale of creating space.
I'm afraid you're not allowed to sort of cross question.
No, fine. It's
but okay, all right. Okay, can I just ask the architect? Just supposing we were to say that this was acceptable, but we wish to add some of the conditions that CL7 would normally have as standard. Do I get the impression that your client would be likely to support that on the basis they just want to get on with it?
I suspect I go to obviously not. They're not. I'm like I kind of on a balance of probability. They would like. I mean, they would genuinely like this house is just falling to rack and ruin over some very kind of, curious arguments. So I'm pretty sure they would just love to just get on there. There were various matters that, helped us along, then sure.
I mean, I'm thinking.
I just feel like if that's what it is, what it is, but ultimately I can't answer them because I'm just not sitting.
All right.
Yeah.
I mean, I'm thinking, for example, a construction method statement, for example, which is a typical.
Yeah, that's right. A typical thing of that nature.
For these sort of
I've done a
developments.
lot of engineering work already to kind of make sure it's all okay. So that.
Yeah, no, I'm not,
Yeah.
I think also there are conditions, possibly we need to, you are well aware that there are tests for conditions. But there might be sort of dust and vibration sort of conditions that again, CL7 typically either require. You suspect your client, you can't speak explicitly, but you suspect that they would probably be prepared to go along with them. Of course, you'll know somebody could always appeal the condition if they thought it was unreasonable. So yeah. Okay. Colleagues, any further questions?
I think
Councillor,
it's not a question more to say. I think based upon those conditions you've outlined, I think I'm satisfied with the application.
Okay. Well, you're getting excited stuff. Are there any other questions to any of the parties here? No. Okay. Thank you very much. If you can return to your seats, please. Thank you.
I do have a question, so I don't know if she would answer that.
Okay. Yeah. Thank you. Okay. So our opportunity to ask officers questions. So who'd like to go first? Barry.
Thank you, Chairman. Alex, question about the triggering of CL policies. I believe, well, I think it's a question anyway. Does it apply? It doesn't apply. If it applies, can we get those reports to be conditioned?
Thank you. So officers have taken the opinion that policy CL7 isn't triggered or isn't engaged for the reasons set out within my report. So the basement policy, so policy CL7 applies to all new basement development. And for the purposes of that policy, as set out within paragraph 6.1 of my officer's report, basement development is the construction or extension of one or more stories of accommodation below the prevailing ground level of a site or property. As referenced as part of my presentation and also within the report, officers have taken the view that the prevailing ground level is the rear and is the rear courtyard or garden area, and therefore the lowering of the lower ground floor and the extension underneath the footprint of the building would constitute basement development, and therefore policy CL7 isn't triggered. If members were to consider that the prevailing ground level was elsewhere in the site and they were to consider it a basement, then that is a consideration for members to take this evening.
Thank you.
Questions? No. I think the sort of heritage point that was raised, because this is not a listed building, is it? There are listed buildings nearby, but it isn't listed. Is it?
Correct, Councillor Husband. So in your pack where you've got the site location plan, you can see the grade 2 listed buildings to the south of the site. The site itself is located within a conservation area, and the building isn't listed.
And I think the discussion that I had with the architect relating to potentially adding some conditions like a construction method statement, a sort of noise and vibration condition. If we wish, we could add those, couldn't we? If we were minded to do so.
So usually those types of conditions or a construction method statement would be provided for basement development, and those would be provided upfront, so officers could make an assessment whether it complies or doesn't comply with policy CL7. If it's kind of disturbance members are concerned about, we have got a condition for a final CTMP to be provided, and also for compliance with the Code of Construction Practice, which requires some additional details to be provided. In relation to additional conditions for a construction method statement or details of any kind of dust or vibration, members would need to consider whether it's necessary to development and whether it meets the test to apply them. Seeing as that officers are of the opinion that it doesn't trigger policy CL7 and the conditions recommended safeguard living conditions and highways in relation to those relevant policies. It's a bit of a difficult.
Yeah, I suppose it's a case of if we were minded to, then we could. I hear what you say about, and I confirm. I don't know how wide that dimension is if I'm doing it, but I do. I take the point about the scale of what is proposed here, and also obviously CL7. But I'm just really thinking of acceptable, some proper mechanism to address some of the concerns that have been set out by neighbouring residents, really. So we could do it if we wanted to. Yes.
If members felt.
I do think the starting point is that you have to consider whether or not it's basement development.
Well,
because if you agree with the officers, and I'll point you to paragraph.
Yes, exactly.
6.4, 6.5.
Yeah, that's right.
You could agree with the officers where the prevailing ground level is, which is three of the sites.
Yes.
And you could agree that it's not basement, but despite that,
yes,
you'd.
Well, yes, thank you. You expressed it perhaps more succinctly than I was. That is exactly the form of argument which I was sort of suggesting, that we would agree with officers that this is not CL. The whole of CL7 is not engaged, but we are mindful of some of the circumstances of this, and therefore we wish to add some conditions of the type that would normally be put to CL7 as a method of system.
If I may, Chairman, I just think you need to be clear, because CL7 is either engaged or it's not. It's not one of those where you could choose. I think what you're considering, if I'm right to assume this, is that there could be impacts of this development to similar to what you may find with a basement development.
Yes.
And it's open to you to add various conditions. You'll see that officers have recommended a CTMP, which is quite unusual for non-basement schemes or non-majors, but we do it quite often when we've got quite tight sites. But I think we need to be clear tonight is whether members do agree whether CL7 has been or not. Well, it doesn't stop you making a decision about conditions, because you can have different conditions.
So let me put forward this proposition to colleagues and see if they agree. I would suggest that we go along with the train of thought set out in the report that CL7 is not engaged. And then, as Lorna Barry suggested, we could then go on to take a step. Now, it's up to us if we did this to add things, as we have already discussed at some length. What do people feel about this? Just very briefly, are we inclined to add these conditions, or should we just leave it?
Chairman, my opinion is that it's clear that it's not a basement development.
Yeah.
Firstly, so it doesn't have to trigger, and then the scale of development is very low. So they're basically extending about a square meter, like 4 square meter. So I don't think condition would be necessary.
Okay, all right. So in other words, you were inclined, but actually after that discussion, which was helpful, just to go to, you're minded to go along with the recommendations. All right.
I'm at the other end of the scale. I'm minded to agree with the extra conditions because it is, even though it's not a new level, I agree with that. It does have the impact of an excavation and in a very particular area with grade 2 buildings, etc. Because of that, I'm inclined to go for the extra conditions.
Right. What you minded?
My view is CL7 is definitely not engaged. Yes. That's the first point, just to be clear. I think if the applicant is happy for those extra conditions, we're happy as a committee. I think being clear that CL7 is not engaged does not preclude us from putting those in. But I actually do agree with what my colleague Councillor Beretti has said. I do think this is small scale. So
yes,
I'm on the fence about the conditions, but I'm very, very clear that CL7 isn't engaged. Yes. I think if we can do the conditions, great, but if not, it's all right.
Let's take reverse there. What do you think?
Not to throw another opinion out there, but I guess my view is that, I mean, the opening that we talk about going on back, things should be like a little window. There's not a door on it. So I don't know how you can consider this the ground floor.
I think it's a lower ground floor. It's quite,
yeah, but
in relation to the rear of the property, it's quite clearly a lower ground floor.
But I guess the argument is that it's ground level. So I guess that's where I would disagree. But given the scale of it, I think it's so small. If we can get it, and the applicant's indicated he's happy with some of the additional regulations.
All right. Right. Okay. I think. Right. I think after considerable discussion, I think I can see where there might be a majority. So I think we seem to feel we're content that the officer's interpretation is correct. CL7 doesn't apply in this case. I think probably on balance, we're inclined to add. I think I would suggest a construction method statement is the principal thing which would give a degree of reassurance. And I think noise and dust, vibration as a result of, would that be covered within the condition, the code of construction?
So the code of construction doesn't specifically mention its condition about noise, dust and vibration. With what members could look to conclude is a condition for a dust management or a small scale dust management plan.
Okay.
I think often we use on
proposals. So that would be a second additional condition. All right. So on that basis, the recommendation is to grant planning permission, but adding in these two conditions which we have just been discussing. So on that basis, can I see those in favour of the proposal, please? So in fact, that's granted unanimously. Thank you very much. Thank you very much. Now, if we can remain in the north half of these, and if we now turn to the site on Kensington High Street, and I think Alice, you're going to do that as well, aren't you? So Alice, go over to you again.
Right, thank you, Chairman. So the application before members this evening is a control of advertisement and consent. So the application side relates to 201 to 207 Kensington High Street. The existing site can be seen on the photograph on the slide before members this evening. the advertisement consent is seeking approval of a mesh advert to be situated on the existing scaffolding. And the scaffolding will have a shroud showing a one-to-one image of the host building and an addition of a advert centrally located, which I'll show you shortly. So this is the proposed front elevation, so members can see the one-to-one image of the proposed building, which is being constructed in accordance with the application granted in, I think it was 2016, as referenced in section 4 of my report. And this is a proposed visualisation of that shroud with the advert centrally located. As referenced as part of my officer report, there is some history on the application site with 2 advertisement consents being refused and upheld at appeal. Since then, there has been some other shroud advertisements granted within the immediate vicinity, and officers are of the opinion that the current proposal is acceptable. This just shows some shroud advertisements which have been approved nearby, and this is taken from the applicant's planning statement with the application property just indicated with my cursor. Yeah. There is some matters to pick up in the addendum report. So I didn't mention at the beginning of my presentation, so I draw members' attention to that as well. That concludes my presentation. The officer's recommendation is to grant advertisement consent subject to the conditions set out in section 9 of my report. Thank you.
Thank you. Any questions about this? This is the old, it's where Robert Dyers used to be a few years ago, actually. Yeah. Okay. No, well, in that case, I think we can probably move straight to a vote. So the recommendation is to grant the conditions set out in the report. And I see those in favour, please. Those against? Okay, so Councillor Wheaton-Sands, Richard Council. Okay, thank you very much indeed. If we can now move on to consider another condition application. This is the CTMP 15 Selwood Place, and I think Jonathan, you're going to present this, aren't you? Swing around.
Yes, thank you, Chairman. So this chart of conditions application relates to 15 Selwood Place in relation to condition 10 of the original planning permission PP/23/03872 that was granted in planning committee last October. And the previous committee had requested this particular CTMP condition 10, to be brought back and determined by planning committee. So here is a slide of the site location plans with the site outlined in red. The site will have an access from Selwood Place and an access to the rear garden by way of Elm Place. And this is just a satellite image with the red outline to show where the site is. This is an extract from the final CTMP submitted. The route of construction traffic would enter from the main road with the blue arrow from Elm Place, which they will deliver the vehicles to stop by the rear entrance at Elm Place before leaving the site through with the red arrows. So turning right from Elm Place to Selwood Place, and then turning right again to Selwood Terrace before exiting to the main road. This is an extract of the swept path analysis within the CTMP, within as available in the members' pack. And this is an extract of further details with regards to the swept path analysis and a diagram of the gantry setup. This is a slide which shows the close-up of the gantry as proposed to be set up. This is the extract of the proposed suspended single parking bay, which to the access of the rear of the site with the white door shown with the cursor here. Yes. Apologies for the lag by the laptop. And this is just an image of what is existing on the street with the rear access shown. Officers are minded to recommend approval of the CTM as set out in the officers report in section 8 of these officers report, and you are also advised there's an additional representation as stated in the addendum.
Thank you. Now, if I can ask Mr. Benham to come to the table, please have a seat. And thank you for waiting. Thank you very much. So please, when you're ready, you go ahead and you have up to 3 minutes.
The objections lodged against the proposed CTMP clearly show why using the narrow entrance to the property on Elm Place would be neither the safest nor the most obvious access to the proposed basement excavation. Although the council's officers, both transport and planning, concluded that this should be acceptable and approved. Indeed, it appears that it was their suggestion that this access should be used, since in February last, I was sent an original draft showing the applicant planned to access from the front of the property on Selwood Place. The council's policies and rules on both basement excavations and CTMPs appear quite clear, and yet officers appear to consider that they are no more than broad guidelines, and indeed can actually be ignored when considering individual applications. The basement excavation is going to be under part of a listed building, which is to be demolished, and to be rebuilt twice as large on top of the new basement. How can this comply with paragraph F of CL7 on page 196 of the council's planning? If this CTMP is now approved, how can the considerable and unnecessary inconvenience for neighbouring residents on Elm Place be said to comply with paragraph K of the same document? In this case, the only residence parking bay to be suspended is entirely outside the neighbouring property on Elm Place, indeed right outside its front door. How can this be reconciled or justified with the requirements of the CTMP form, which states the suspension of residence parking bays outside other properties will not be allowed? Indeed, by using the Elm Place access, only 20% of the proposed on-street access site will be outside the property, the vast majority being directly outside the neighbouring houses. In spite of these matters, the officer's report concludes that the proposal complies with the requirements and should be approved. In dealing with specific objections raised, the report appears to make several inaccurate and irrelevant observations. It states that using the front of the property would still need vehicles to approach the site via Elm Place. They could just as well approach Selwood Place via the Selwood Neville Terrace entrance, would not have to negotiate across the traffic flow to enter the proposed access site, nor to do so very close to the blind junction between Elm and Selwood Places. The report also suggests that the suspended Elm Place residence bay would be available to residents overnight. True enough, but such bays are in fact available to anyone, whether resident or not, overnight. And surely one purpose of residence parking bays is that cars can be parked at all times unless they're suspended. All in all, the report reads so as to recommend approval of the proposal for the convenience of the applicant, in spite of the genuine concerns raised in the objections. For many weeks, for several hours each working day, the only no parking zone on Elm Place, which allows two-way traffic at the northern end of that street to pass, will be unavailable. This will result in considerable congestion and significant safety issues, but another much less difficult site could have been chosen, largely avoiding those problems. Whilst the CTMP states that no skip license were required or applied for, a further application for this development has now been filed, stating that one will be required, but no indication given as to where this might be. Again, the council's rules state that skip licenses will not be granted for skips outside other properties. But in this case, if such a skip is required on Elm Place, it would have to be, at least in part, outside another property. The CTMP should not be approved unless and until it has been clarified whether or not a skip license will in fact be necessary.
Time is more or less up. So, okay, thank you very much indeed. So colleagues, if there are any questions to Mr. Bennett. Can I ask you a question? My understanding is that the applicant actually owns, it's rather an odd L-shaped property, so they actually own some frontage on Elm Place. So the
about 6 feet, I believe. I mean, I'm not, I don't own the property, but I live there. I know where it is. It's about 6 feet wide.
Yes.
A back passage.
Yes, I mean, it's
directly between the walls of two other houses, not their gardens or anything else, but actually their house wall.
Yes, okay. I understand. Okay, I just wanted to clarify that. Okay, thank you very much indeed. Please, Tim, if you want to.
One very quick question, just looking at this particular picture here, that blue paint bit, is that a car garage?
Well, it used to be, it's now a dining room.
Oh, it's not a dining room.
That's a granted chain with the approval of the council.
Right.
By the owner of that house. And the little thin blue door is also belongs to the big blue door.
Thank you.
Okay. And perhaps continuing on in the same vein, if the part of Selwood Terrace in that photograph that we're looking at, the part that is it's part of the applicant site is the white door there that we see more or less in the middle of the photo.
Oh, that's Elm Place, not Selwood Place.
That's right, I think, but I'm saying it's owned by.
The white door is the applicant.
Yeah, it's the applicant.
And I think that, as far as I know, the two bits of brickwork around it.
Yeah, but I would imagine so. Please do not try and express this using your arms. Extremely helpful. Okay, so the green, the sort of teal coloured door in there that's actually another property on Elm Place.
Correct.
Right. Okay. All right. Thank you. Please, any other questions?
Quickly on the CTM.
Yes, of course.
So you're happy for the vehicles to use this door as opposed to the one on Selwood Place? Is that what you're proposing?
I'm not proposing.
No.
The applicant's proposing. Yeah. And as I understand it, that yellow line, which you can see there, is the area where all these movements can happen. And that is the one place on Elm Place where traffic can actually pass. And it's a two-way street, but it has only one lane of traffic in it, and cars pass on both sides. So without that, you cannot pass another vehicle going in the other direction.
So, okay, because the rest all are parking bays, essentially.
Parking bays all the way down, and you get to the Fulham Road end.
Right, I understand.
Thank you very much indeed. So if you retake your seat. So questions to officers who'd like to go first about this.
Well, just one brief question. It's in relation to the width of the highway. I think relation to the objection, and in your response to that, you say the width of the road would be sufficient to accommodate setup proposed. The track drawings in the CTMP show the body of the vehicles overrunning the footway, not the wheels. Just thinking, given the sort of size and width of the road, is it usually acceptable for the body of these large vehicles to overrun the footway? Would there be any risks to that? And is it reasonable to specify that more narrow vehicles be used?
In terms of what this diagram shows, it is wider than a typical private car. But in terms of in the context of CTMP, the council's transport officers has considered that there would be no impact on safe and free flow of the highway, despite that the shown tipper vehicle will be slightly wider than the bays themselves. So the council's transport officers have considered it to be acceptable.
And just the final part of my question, is it something we can do as a committee to specify that more narrow type of vehicle be used, or is that not something that we're able to do? There must be similar vehicles that are not quite as wide.
Well, it's difficult I mean, you're obviously looking at me, but it's difficult for me to say because I haven't had any involvement in.
I think
So the
I think because the way the plan has been prepared, and the plan is a holistic document, i.e. it's not it's individual question, but you're looking at it as one document, so an answer to one will feed into another. I don't think it's possible to redesign elements of it.
No.
And also it may require input from highways colleagues because they are perhaps more well versed in such matters. So I would suggest that you consider the CTMP in its current form. If it's not acceptable, then we can minute what our preference might be going forward, so the applicant is aware of that.
Thank you. That's very clear. Thank you.
So Lisa, just one question. So can we add as an advisory in form to use vehicles that could allow other people of the highway?
You could, but an informative is just an informative. It's not binding in any way.
But
So
it's we were specifying that.
yeah, so it's just to inform the applicant they could go ahead and apply the CTMP that's before us, which by the sounds of it you've got concerns with. And from the enforcement point of view, that informative wouldn't mean very much.
Okay, that answers. Yeah. Okay. I think I have the danger of asking Lisa Churner a question, which I think I do know the answer to. Refusals of CTMPs that have been professionally produced. Is that something that, if it's appealed, what tends to be the outcome of that?
Well, it's a bit of a mixed bag, I think, at appeal. I think it comes down to the argument that you make and how good that is. Another option available to you, we don't use it often, is you could defer the item for the applicant to go away and consider the size of vehicles to be used. And then it's, amendments are made to that or not. The applicant could tell me, I'm not going to make an amendment. But either way, we would bring it back and then we can make a decision.
I don't know. Yeah, thank you. So moving on, does that seem a reasonable option for us to defer the application on the basis that they should look again at the details and in particular the possibility of using smaller vehicles? Does that seem reasonable?
From my perspective, that would be helpful. I know these roads quite well in the corners, and I have some concern that a vehicle that overhangs, albeit not the wheels, but the rest of the vehicle overhangs the pavement, is perhaps too wide. So I think that could be a good course of action.
Okay. Are you minded to go along with that kind of thought?
Happy to make a decision now.
Okay.
I don't like the location of the skip and the impact on the direct neighbours of it. In agreement with the objectives, I think it would have been a better idea to do it on the other side. So because of that, I'm more inclined to just say no to the whole CTMP itself.
Okay, well, I think we've obviously got a variety of views here. I think I detect that probably the deferral option does have a majority. Now, Lorna, should we start by having a vote as to the recommendation is that we
No, because
we approve?
it's either going to be approved or refused. But if you want to defer,
yes,
then it'll just come back another day. So I think you just propose and second a deferral and just see where that leads us.
Okay.
And then
yes, no, I think I'm quite content with that. Okay, so Councillor Lane has proposed a deferral. I'm quite happy to second that. Can I see those in favour of the deferral on that basis? Those against? Okay, so the deferral is carried by 3 votes to 2. So that's the decision. Thank you very much indeed. Thank you. Can we now move on to consider 49 Blenheim Crescent, which is in the North Back. I think Jessica, you're going to do these. Yeah. Very good. Okay, thank you very much. Yes, of course, please start. Thank you, Eric.
So, four members this evening, application of all time planning. So, members be aware that there is no building. So the application site is indicated by the red arrow on the slide. The application seeks planning permission for several works, including the construction of a single-storey basement, a lower ground floor extension, second floor rear extension, roof alterations and dormer window, and a new AC unit at roof level. The existing and proposed rear elevations can be seen on this slide. The red arrows draw attention to the main elements of the visible form to the rear, and these include the lower ground floor rear extension, the roof dormer alterations, and the extension at second floor level. The existing and proposed sections can be seen here. The proposed basement is single story and will be sited underneath the footprint of the building, will project to the rear. The lower ground floor extension will be seen indicated by the red arrow. Recommended condition 9 restricts part of no extension to be used as a terrace. To conclude, it is recommended that planning permission is granted, subject to the recommended conditions set out in the officer's report.
There are no speakers for this case, so we move straight to questions.
I haven't registered to speak, but please wait for if I can make an off the record.
No, I'm sorry. You can't at this stage speak. So questions to officers, but it's. I'll start. There's quite a lot proposed here. Quite a lot going on in this building, but it seems, if I've understood correctly, that really the principal alterations really relate to the rear of the property, and also to the roof, which is being changed relatively fundamentally. Is that right? Have I understood the drawings correctly?
Yeah, I believe so.
Yes. Okay. Police, any other? Okay. Well, in that case,
sorry,
yes.
I was getting my thoughts on that.
Yeah.
I seem to remember that one of the concerns of the local residents was that during works, there were concerns about privacy because they had to do a temporary construction, if I remember correctly. I think residents were concerned about privacy in their existing homes on the back of that temporary construction. I seem to remember in previous cases we proposed privacy screens during work. Is that something that could be considered?
That is something that could be considered to be added as a condition if members were minded to include that to prevent any privacy concerns. But we have kind of concluded that during those temporary work, there wouldn't be significant impact to the privacy of neighbours.
Okay. And then the other point I wanted to double check, and that's actually what wasn't, I think, and sorry, there's so much paperwork, I'm trying to making sure I get everything correct. Condition 17.6 on radon, the last sentence of that paragraph is cut off, which ends with please on adopt.
Condition
17.6 with the title radon. I'm just wondering if radon is identified above 100 BQ per cubic meter during future monitoring, please, and that's where it ends.
Oh, sorry, I'm informative.
Oh, sorry, is that informative? Sorry.
Right. Yes.
This is, sorry.
Oh, yeah. I can see, yeah. I don't know. Been cut off. Yeah, I've been cut off. I don't know off the top of my head what that is meant to say, but I'm sure we can find that out and add it onto the final decision notice before it is published tomorrow.
Yeah, it will be to contact.
Yeah.
The relevant body.
Yes, I would think it's to contact environmental health, who in turn would be aware of how matters to do with radon were fitted in with the health and safety executive. I think that probably, and we should certainly, if we were minded to grant this, we should complete that informative along those lines, I would suggest.
Fine, it will be on the environmental health response plan, so I just make sure that we have that, and thank you for bringing that up.
Thank you. Yeah.
Thank you, Chair. Just want to draw attention to the objection that Sophia Lambert, and specifically where she mentions rather than mounting railings on the wall, taking the applicant will consider reinstating full height railings to match those on number 51. Now, looking at the recommended conditions, condition number 3, I know we're still waiting for submission of details, but you talk about section A of condition 3, alternative front boundary treatment metal railings detailing to better replicate the railings on number 51, essentially. So I just want to check it, has that concern from Mrs. Lambert been addressed by that condition 3?
Yeah.
Brilliant. Okay. Just wanted to do that. Thank you.
That sounds good. Okay. Okay. Well, in that case, the recommendation is to grant the conditions, and also we are completing that informative that as the correctly picked up on. Can I see those in favour of the recommendation, please? Those against? So that's granted 4 votes to 1. Thank you very much. Thank you. If we can now turn to the planning permission and listed building concerns relating to the property in the Kings Road. So Jessica, you're doing that as well.
Yes, this application relates to 195-197 Kings Road, and it's formerly known as the Ivy Restaurant. Before members this evening is both considerations for planning permission and listed building consent work. So here is a site view of the proposal. You can see that it's kind of between the buildings to the rear in the kind of courtyard type area. And the proposal specifically relates to work for the existing garden structure. So it's at the moment it's kind of timber and glazed with awning above. And the application seeks permission to slightly change the roof so it's more glazed and thick, and then to also improve the sidewalls of the current pavilion. So the kind of masonry wall at the bottom remains the same, and then the parts above are altered. So the officer's recommendation is to grant permission in accordance with the conditions in the pack, and there's specific conditions relating to kind of noise and music, which have been included to reflect the applicant's submitted noise report. That concludes my presentation.
Questions? Okay. So now we have 2 decisions we have to make. First of all, the planning permission. So the recommendation is to grant as set out in the report. Can I see those in favour of granting this? So that is agreed. The listed building consent, is there anything further that you wish to add?
No, just that would also come within the officer's report. They say with the main planning application.
In that case, the recommendation is to grant listed building consent. Can I see those in favour of granting? So that's granted this one. Thank you very much indeed. If we could now turn to the application Westbourne Grove, please. That's back in the north.
Thank you, Chairman. Application for members for planning commission at the upper base at first and second floor flat of 209 to 312 Westbourne Grove. I draw members' attention to the addendum report which will be outside of. So the application site relates to the upper Maisonette flat, and the application seeks permission for the replacement of 3 existing air condenser units with air source heat pumps, installation of an additional condenser unit, and the installation of 11 PV solar panels. And I believe these are all located at the schedule of the current application site. The existing and proposed roof fan can be seen on the screen, and the red circle marks the proposed development. Red circle is marked. It is recommended that planning permission is granted subject to the recommended conditions set out in the officer's. Happy to answer any questions.
Any questions relating to this? I think it's obviously quite a substantial roof area here where this is development is going to take place. So there is space to put these to install these things without them being extraordinarily conspicuous. So any questions? No. In that case, the recommendation is to grant permission with conditions attached. Can I see those in favour of granting, please? That is agreed. If we can, I think, stay in the some reason it's well, that's actually in the south back. So if we now turn to the application at Kensington Mansions on the Warwick Road, Jessica, back to you.
Thank you, Chairman. Yeah, application for members for the replacement of windows at Kensington Mansions. Applications for 4 members because it's an RBKC own application, so therefore to come to committee for a decision. On the screen is the application site. To the top left, you can see the development site, and then there's some existing well, kind of there'll be like windows that existing slash proposed, but with the red boxes to denote the areas of windows to be replaced. This is on the northeast elevation. This is on the southeast elevation. That concludes my presentation. Back to answer any questions.
Thank you. So it's quite extensive, all the windows being replaced. Any questions about this?
So, I mean, is this a residential property?
I believe so, yeah.
Warwick, yeah, I was just wondering if it's towards my opponent, so I wasn't sure. All right, okay. That's all you needed.
Okay, so the recommendation here is to grant with conditions attached. Can I see those in favour, please? So that is agreed. And finally, this evening, this is still in the south back, the last application, and this is the application on highway adjacent to 1 Montpellier Street.
Again, this application comes to committee because it is an RBK to the own application and therefore requires a decision from committee members. The application site relates to an existing flower kiosk unit located on the corner of Montpellier Road. This is an aerial view of the existing unit. So the proposal seeks to replace this unit with a slightly larger, more robust unit that has kind of opening awning sides, and it would be located in roughly the same space. Highways colleagues have been consulted and are satisfied that it would be okay in highway safety terms and the suspension of some additional motorbike spaces. Closed view of it. There's been a significant number of supporting letters